The documents to expect when buying land depends on where the land is located. But before I go further, I need to be clear on this. Ownership of land in Nigeria is ultimately vested in the governor of the state or the FCT minister under the Land Use Act. In the light of the above, it is supposed that every valid interest in land must either flow from the government through a direct allocation or a deemed grant for those who were in possession before the coming into effect of the Land Use Act of 1978. What the government gives to you is a right of occupancy. Urban area is the state capital and any other place or location designated as an urban area by the governor or the minister. Now, the Certificate of Occupancy, which is commonly called C of O, is the proof of right of occupancy. Note, however, that C of O is not a conclusive proof of right of occupancy. Until the contrary is proved, however, it is regarded as a confirmation of a person's right of occupancy over a parcel of land, usually granted for 99 years. In one of my videos, I explained the controversy surrounding expiration of Certificate of Occupancy. Some people were agitated that once a property is nearing 99 years, it is a risky investment offer for anybody to invest in. I dispelled that rumor. It is unfounded. It is not found anywhere in the Land Use Act, and it hasn't been practiced anywhere. So if you are buying any property, even if the lifespan of the C of O is remaining just 1 year, don't be afraid, go ahead with it. But for clarifications and for deeper understanding of what I'm talking about, I would want you to watch that video. Now, going ahead, R of O or letter of allocation precedes the issuance of C of O. However, a C of O must be verified. This is important because the courts have severally held that a C of O is not a conclusive proof of land ownership. Mind you, C of O can be cloned. It can also be issued in error. That's why it must be verified strictly. Generally, even if a C of O is genuine, it does not automatically mean the land is free from encumbrances. Always use encumberedproperties.com for your re-verifications. Now, the emphasis I want to lay on C of O's so that people don't get carried away once they cite C of O is this. As I earlier said, you need proper re-verification because C of O's have been issued in error. People have processed C of O's over properties that don't belong to them. I have a classical example. Somewhere, Kefi, Abuja Road. I bought a property there, then I gave it over to someone because development had not gotten to that location to be farming, and some people came claiming ownership and all that. I'm too busy to begin to, go to police, go to court and all that. But the young man I gave it to be farming and taking care of the land was getting feedback across to me. In one occasion, they had to go to the police. They asked for documents. I sent across, and the police now referred us to the traditional ruler, the emir of the location. They called, my vendors appeared. The vendors of the man also appeared. And before this time around, and before we got to this point, when I bought, I didn't, try applying for R of O. I didn't bother about the C of O. That is why it is risky. When you buy, you must take steps to perfect your title. You understand? So I didn't do all that. What I have is equitable title. However, when we paid for site inspection, the two parties, the two vendors on both sides, we are present. That was where the people who sold to this man who came and encroached into my own property now told him, no, this is not where we showed you. This is not where we sold to you. That was how the whole air was cleared. And before this time, this man had gone ahead of me and obtained R of O from Nasarawa State government. In fact, when I sent the details of the location to NAGIS, Nasarawa State Geographic Information System, when I sent it to them, they told me, this land you are talking about is registered in the name of so person. What was his name? I think one Mr. Jerry. That is registered in the name of Jerry. That was when I was like, it's almost late for me. I virtually gave up. I thank God for that young man, one Mr. Philip Faithful. Faithful is actually his name. It's not because he did this to me. Mr. Philip Faithful is a colleague at work. So he followed up, and by the end of the day, visiting the site clarified everything. Why I'm saying this is because which I had given up when I got the information from Najis, that he had registered, obtained the R of O, and in the process of obtaining the C of O. So if you obtain a C of O on a faulty foundation, on a land that is not supposed to be yours, ab initio, it won't hold water. In other words, that's why the courts have severally held that C of O is not a conclusive proof of ownership. However, it stands until the contrary is being proved. Next is a deed of assignment. Every transfer of interest in land must be by way of deed. It's a legal requirement. A deed is a special type of legal document used to formally transfer or create an interest in land, like transfer of right of occupancy, lease, mortgage, or easement. Now, a deed of assignment is principally used to evidence the transfer of right of occupancy, as I've earlier said, from one party to another. Even a property with a C of O still needs a deed of transfer for it to be validly be given to another person. If you bought land from someone, deed is the document that legally proves that right over that property has been moved to you. But here is the catch. A deed of assignment must be registered at the land registry. This is part of the steps towards perfecting your proof of title. Registration of the deed means officially recording that transaction at the relevant government land registry so that the transfer of land will be recognized by the state and becomes part of public record touching on that piece of land. In simple terms, you don't just buy a property, sign the deed, and keep it in your drawer, as I did in my explanation earlier on. You take it to the land registry so that records about ownership of that land can be updated. An unregistered deed is weak. It may exist, but it does not fully protect you against third parties. An unregistered deed confers only what we call equitable interest and not legal interest. The next is registered survey plan. This document defines the exact location, size, and boundaries of the land. A survey plan answers one critical question: where exactly this land is located, and does it overlap with government acquisition, excision, or another person's land? If a seller cannot produce a verifiable survey plan, you are blindly going into a transaction, and that is a red flag. A registered survey is an official survey plan of a piece of land that has been prepared by a licensed surveyor. The survey having been approved and recorded by the government surveyor office, example, the Surveyor General's office in the state or that of the federation, as the case may be. It shows the land's boundaries, measurements, location, coordinates, size, and shape. Basically, it's the official map of your land. But note that a registered survey plan is not a title deed, it's not a title document, but merely a pointer to the location where the land is. Someone marketing an estate somewhere in Aba, let me be specific, P1, they call it Oriental Estate Aba. They say what they have, or one of the titles they claim to have, is registered survey. And someone contacted us asking us to investigate. On the face of their advert, they don't have title. The title in question, you must have what? If you have deed of conveyance, you have to obtain governor's consent. Governor's consent. You can't be trying to develop an estate running into hectares within a state and you don't have governor's consent over the land. We are not talking of building approvals yet. And do you want people to give you money? And what you say what you have is registered survey and probably power of attorney. Why not perfect your title over the document before rushing to the members of the public to ask them to give you money? So if you are the one that contacted us over that particular property, I think this statement already answers the question you are trying to ask us. There must be a valid title recognizable by the law. And under Land Use Acts, we've already explained the documents that are recognizable by law. Even if you acquire it not through any letter of allocation, you have to take steps to perfect it. Because why it is necessary for you to perfect the title is this: if peradventure, after collecting money from subscribers and government refuses for physical planning reasons not yet known to you or disclosed to the developer, says no to the siting of that estate in that location, what will you tell your subscribers? For the sake of the explanation I gave with respect to rental estate in Aba, and this statement I just made now, that once an allocation came by the way of statutory right of occupancy and the subsequent CFO, it must obtain governor's consent. When a land is also obtained through the natives, they have settled with you, giving you deed of conveyance, you still have to go over to the land registry and process the requisite approvals, including the governor's consent. In this particular circumstance, it is still needed. It is not only when it is via right of occupancy, statutory right of occupancy for that matter. Now, let's talk about excision and gazette. If land is within an area acquired by the government, the only way parts of the land or the entire land can be legally released back to the people is through excision and published in the government's gazette. Gazetting is an official proof that the government has released the land back to the original communities or owners. Once a location has a history of once being acquired by the government from a community, the community must produce proof of excision and gazetting before you buy. Otherwise, you are stepping into an investment trap. Now, next is judgment or court order. But this one requires extreme caution because some sellers rely on court judgment as proof of ownership. While judgments can be valid, many are limited. Many of those judgments are limited, contested, or do not cover the exact portion being sold. Never rely on a judgment alone without deeper verifications. Are all the interested parties aware of the suit that gave birth to that judgment? You have to find out. Are you sure there are no pending appeals against that judgment? Is there no other suit pending in another court or courts against the same property? These are the things you need to verify before you rely on a court judgment as proof of ownership or title to a particular property. Now, let's talk about documents that do not automatically prove ownership, even though they are commonly used to deceive buyers. Receipt issued to you by a family, a community, allocation letter from a community does not equal ownership. A letter from a Bale or Omonile does not equal ownership. These documents may show history, but they do not give you legal protection unless they are further backed up by a deed and perfected by taking the necessary steps. This is where many people get scammed. They see stamps, they hear titles, they believe, with confidence, and they ignore verifications. At encumberedproperties.com, our rule is simple. If the document cannot be verified or be traceable, it does not protect you. Before you pay for any land in Nigeria, always ask who owns it legally. What document proves it? Are they recognizable documents? Has it been registered? Has government consent been obtained? Is the land free from acquisition or dispute? How do you find out all this? Encumberedproperties.com is there to answer all these questions on your behalf. Generally, every land vendor needs to produce the following documents before you buy: allocation letter, if it is from the government, registered survey plan, payment receipts, and certificate of occupancy. Those are the necessary documents you must cite. From what I've explained, you now know what to look out for. Basically, if it is a property in an urban area, you have to see the offer letter, which is often in the form of RFO. You have to know whether the CFO has been issued, because RFO precedes CFO. If the CFO has been issued, you have to see it. You have to cite the survey plan of the property. And for the property to be transferred to you, it has to be by a deed. And if it had been transferred to somebody else before you, from the original allottee, you have to cite what? The deed. If it is a registered deed, better. If it is not registered, you risk the chances of another person having registered it before this particular transaction. That will take you to the land registry to search, and that will also need to take you to encumberedproperties.com to confirm whether anybody had enlisted that property under our red flags as encumbered, disputed, or otherwise. Then, if it is a property that is off urban area, you check whether it has what we call customary right of occupancy issued by the local government. If it is also not yet issued, you can settle with the people who have what we call deemed customary right of occupancy. In other words, people who are in possession before the coming into effect of the Land Use Act. These people are called people who are deemed to have the customary right of occupancy. So when they apply, or when you apply as having obtained title through them, the government will ratify your application. So depending at the stage you are coming into a land transaction will matter to the documents that should be available. You might not know this because of the technicalities involved. That's why encumberproperties.com exists. We have a due diligence unit, people who are expert in land deals and transactions. You contact us by a direct message or through any of our links, and we will be able to see you through. If you want to avoid scam, you need to avoid assumptions. And if you want to remain above and ahead of property scams, you need to get hooked to this channel so that our real estate updates and tips will keep you ahead of property scams. Here also, we'll bring to you details of risky real estate offers anywhere found so that you can learn of them and avoid falling into such traps. And you can get smarter with your real estate investment deals by getting these 7 steps and guides to acquiring a clean property title. It is a practical checklist. It is 7 steps you take and you'll be guaranteed that any land you are getting is foolproof, scam proof. The link to order for this important manual is in the description to this video. And for the safety of others, we would want you to share this video so that they will learn. Partner with us in our bid to making the real estate sector free from fraud by reporting to us any risky real estate offers people are using to defraud people anywhere, so that we will use it in sensitizing the members of the public. You don't know whom you may be helping with that piece of information. I remain Madweke Enwere. I'm a real estate lawyer, a chief superintendent of police, and by God's grace, the founder, Encumberedproperties.com. We remain the only real estate fraud prevention platform. We love you and we care about the safety of your real estate investment. Thank you.